Thank you for joining us today at the New Mexico Department of Justice. Today we are privileged to be joined not only by individuals and advocates who have long worked doing some of the most difficult and challenging work you can inside the criminal justice system, and that's being an advocate for victims. But we are privileged to be joined by people who have experienced firsthand the way in which the New Mexico criminal justice system fails to adequately protect victims of crime. As a career prosecutor who has worked in both the state and federal system, I can say unequivocally that New Mexico has the sad distinction of being one of the least protective states in the nation when it comes to victims' rights. And this should come as not only a surprise but a shock to the citizens of our community, because victims of crime in this state have their rights enshrined not only in the New Mexico Constitution, but also in a separate statute that states quite clearly that victims are entitled to privacy, dignity, and respect throughout the criminal justice process. And unfortunately, all too often, the rules that we operate under in our criminal system simply doesn't place the rights of victims on equal footing. And so today we are proud to announce and support two specific bills that we hope will add much needed protection for young people, victims of sexual violence, and others who have the courage to report their crime, who have the courage to step forward and work with law enforcement, and expect nothing other than to be treated with dignity and respect throughout that process. The first bill is actually a bill that has been under discussion and consideration by the body for quite some time, and has been presented in I believe, in last year's session, to limit the ability of defense investigators and others to interrogate child victims and other victims in a pretrial witness interview in such a way that they harass and intimidate those victims, and frankly, with the ultimate objective of trying to discourage them from participating in the process. The pretrial witness interview process itself is unique. We are one of only a handful of states in the country that permit an adult to interrogate a child about a traumatic sexual assault or physical or an incident involving child abuse. And so we are proud to stand in strong support of Representative Tara Jaramillo's efforts to expand the protections that we afford to victims of crime and align that process with not only the constitutional guarantees but the statutory framework that's been in place. But before we hear from Representative Jaramillo, I'd like to invite Christina Udvardy, the CEO of All Faiths Children's Advocacy Center, to step forward and talk a little bit about why it's imperative that we protect victims, particularly young victims, in the pretrial interview process, and what this legislation would do to really align the values of our community and the needs that we have for placing the most vulnerable people in a position where they are respected throughout the process. So, Christina.
Thank you. Thank you, Mr. Attorney General, and thank you, Representative Jaramillo, for supporting this bill. Since 1956, All Faiths Children's Advocacy Center has been a trusted advocate for children and families in our community. We are committed to protecting children who have faced trauma, ensuring that they receive compassionate and trauma-informed care. Our mission is to advocate for practices that aid in children's recovery and development, rather than subjecting them to processes that could inflict additional harm. Today, we address a critical issue: the harmful effects of requiring children to repeatedly disclose their traumatic experiences. Research shows that multiple disclosures can significantly hinder a child's recovery and development. Repeated exposure to trauma through repeated interviews increases the risk of developing PTSD, anxiety, and depression. This process can lead to re-traumatization, where children are forced to relive their trauma, reinforcing feelings of fear and shame, helplessness. thereby disrupting their natural healing process. As advocates, All Faiths works to minimize these harmful effects. Our trauma-informed practices limit the need for multiple interviews. By using the Child Advocacy Center model, children are interviewed only once in a safe, child-friendly environment by our highly trained staff, reducing distress, which in turn results in a more positive experience within the legal system. The consequences of multiple interviews and disclosures extend beyond the individual child. Unaddressed trauma can have long-term societal impacts, increasing the risk of mental health disorders, substance use, and other challenges. By adopting trauma-informed practices, we not only support the child's healing, but also address broader societal issues, reducing costs related to healthcare, education, and public safety. Our advocacy extends to actively supporting a child's recovery. Children receiving services such as trauma-focused therapy exhibit significant reductions in trauma symptoms. Our interventions also lead to increased caregiver support and engagement in mental health services, which are essential for a child's recovery. Through our advocacy, we seek to reshape how the legal system responds to child trauma, focusing on practices that prioritize the child's development and well-being. No child should have to relive their worst experiences repeatedly. By supporting trauma-informed approaches and legislation, we create a path to recovery that empowers children to heal and move forward to live a healthy and productive life. Thank you very much.
Thank you, Christina. I want to echo the concerns that she has about the way in which the current system re-traumatizes children. I can speak to that from personal experience as a frontline child abuse prosecutor. I still remember the first time that I sat down with a child victim no more than 6 or 7 years old, and she sat across from a criminal defense investigator who, over the course of the next couple of hours, proceeded to ask her graphic and detailed questions about an offender who had victimized her over the course of several months. And fundamentally, what we are talking about is a justice system that delivers justice to everyone who participates in it. We have to balance the rights and interests of the accused, but that doesn't have to come at the expense of the well-being and the health of children. But it isn't just children that we are concerned about, because we have seen many times that adult sexual assault victims have been demeaned, have been interrogated, and have had to endure a pretrial process that makes them, frankly, unwilling to participate anymore in that process. And for that reason, I'm glad we're joined today by an attorney, Mike Hart, who has specialized in representing victims of crime, who has witnessed this practice over a number of years. And I think it's important to have his perspective on what this bill would mean for his clients and for victim participation across the board. So thank you. Mike.
Good morning. I and my partners have dedicated decades to representing crime victims in a lot of all different kinds of settings. And what's important today is, as the Attorney General has described, New Mexicans have always and for a long time recognized that the rights of the victim of a crime must be balanced with the rights of the accused. We talk a lot about the rights of the accused. We all are fairly familiar with what our Bill of Rights provide for the accused. We don't talk much about the rights of the victim. New Mexico has it in our Constitution. It is in our statutes that the rights of the victim of a particularly violent crime must be balanced with those rights of the accused. And that's what the Attorney General and this bill and the legislature will be discussing and implementing with this new legislation. This office has long advocated for the rights of victims of violent crime, child abuse, rape, other very, very invasive felonies, first-degree felonies, and other violent crimes. These laws will establish the appropriate protections crime victims are entitled to under our law and will give judges, this is critically important, it'll give judges guidance on how to do that balancing, how to weigh the rights of the accused when confronted with the rights of the victim to be free from invasive and unnecessary and traumatic experiences as the criminal justice process moves forward. We're very, on behalf of all the clients I've represented for a long, long periods of time, we're very thankful for the efforts of the legislature and this office in advocating and pursuing those remedies and those rights through clear legislation. Thank you.
Of course, none of this would be possible without strong support and leadership from members of the New Mexico legislature who have taken the lead in not only standing up and fighting for important public safety issues, but also drawing a line in the sand over the importance of protecting victims. And Representative Tara Jaramillo is just such a leader. We are proud to work with her and to partner with her. Her advocacy on behalf of children goes back decades, and her commitment to these issues is something that I know we appreciate and all victims of crime in the state of New Mexico appreciate. So with that, Representative Tara Jaramillo.
Thank you, everyone, for being here, and thank you to this group of people who are dedicated to ensuring that victims of crimes have equal protections under the law. And if there's anything we take from this, I would hope that we would take away equal, and also the comments that we need to support children and victims of crime from interrogation. And interrogation, I think that should sit there for you to hear that. I'm Representative Tara Jaramillo, and I represent House District 38, which includes parts of Doñana, Sierra, and Socorro counties. I'm also a speech-language pathologist, and I work in a child and family advocacy center. I'm also a mom, and I'm a grandmother. We have all either read or seen on the news or experienced the heartbreaking stories of children who are abused or neglected and failed by the very system that existed to protect them. The consequences when these systems fail can be devastating for our children, for our families, and our communities at large. Whenever a system fails, a child is ultimately harmed. We have to pay attention and try to understand what happened, and then what we can do differently. But when a child is a victim of a crime, it can be difficult for them to have to be repeatedly sharing their story about what happened to them. The same can be true for adults who are victims of traumatic sexual assault. No victim should be forced to unnecessarily relive their trauma over and over again. Yet all too often, this is exactly what happens in our current system in New Mexico. Right now, in the state of New Mexico, victims are subject to invasive and lengthy pre-trial interviews by defense attorneys. This can be particularly harmful to our children because defense attorneys are not trained to conduct these interviews that prevent emotional trauma to the child victim. Forensic interviews give law enforcement the tools they need to investigate these serious crimes, while ensuring that victims are protected from unnecessary trauma within our criminal justice system. This allows trained professionals to gather factual information to determine in a lengthy, defensible, and developmentally appropriate manner for that child and that victim. Our proposed bill would expand protections for children and sexual assault victims involved in criminal proceedings by preventing child victims or witnesses from being forced to give a pretrial statement or interview, and allow for adult victims to refuse or limit such interviews. Our proposal would also require courts to reject irrelevant or repetitive questioning that can cause harm to the victim. These important updates in this bill will prevent the re-traumatization of that victim, strengthen our victim protections, and prevent them from facing undue pressure during criminal proceedings. Because forensic interviews are already used in many other states, this bill would also bring New Mexico in line with the rest of the country in how we work with children victims and adult victims. I'm grateful to our Attorney General for including this important bill in the slate of legislation for victims of crimes in New Mexico. Our justice system should always serve the best interests of children, especially when they've become the victim of a crime. Thank you so much.
In addition to providing important clarification on the types of protection that both child victims and adult victims should enjoy inside our criminal justice process, recent events across the state of New Mexico have made it abundantly clear that we need to add new weight and enforcement authority for the vindication of victims' rights. To put it bluntly, victims' rights are the only rights under New Mexico law where there is not a clear statutory authority to bring either a private right of action or civil enforcement action. And unfortunately, that was made abundantly clear recently in a tragic case in Doña Ana County where several young women had the courage to step forward and hold a teacher in that community accountable for his grotesque criminal conduct. And what was even more disturbing in the course of that proceeding is that the judge in that case decided to cut short the mandatory probation period for that particular defendant without bothering to notify the victims of the crime. And I want everyone who is thinking about this to imagine what it must be like for a young person, for a young woman who has had the courage to navigate this process, to endure pretrial witness interviews, to go through the challenging and very difficult ordeal of dealing with law enforcement and a court proceeding, to have someone who is supposed to be protecting the rights of every citizen in this state deciding that her rights somehow had less meaning than the rights of a criminal defendant. That's not who we are as a state, and for that reason, we are advocating for a new bill that would create clear procedures for providing notice, but guaranteeing that each of these victims are treated with dignity and privacy throughout the process, and that if any member of the criminal justice system fails to uphold those principles, fails to provide guarantees to victims that their rights will be respected, that we will be held accountable. And I say that intentionally. We, even prosecutors, will be held accountable for any violations of the Victims' Rights Act or the guarantees provided under our Constitution. Because to do anything less would be to maintain a status quo that treats victims in this state as second-class citizens, and that is simply unacceptable. To provide, I think, a much-needed perspective on the real-world impact that this kind of disregard that we see inside of our courtrooms have on our families, on our children, on our communities, I'd like to welcome Tony Dronga to give a few remarks about his experience in this regard and the impact that this legislation may have for him and people like him. Tony.
I'm sorry. So I have a story for everyone, and I hope you listened intensely, because it could be your kid who this happens to. I have a story about the lack of victims' rights in the state of New Mexico. It's not a short story, but I'll try and keep it short, and I hope you listen. In the many cases against a single defendant, Patrick Howard, of Las Cruces, New Mexico, in Doña Ana County, he sexually assaulted his victims, many of who were minors. one of which was my daughter. Patrick is a man who abused his power as an educator, damaging countless young and brilliant children, and then was able to bend the rules of justice in his favor on many occasions. Trauma to these children was further exasperated and exacted upon them when they were silenced by the criminal justice system for a period of 7 years. We've lived this for 7 years. And again, when the system and the offender expressed disregard and clear contempt for the Victims' Rights Acts and their current provisions. And they did so in court. Then, even again, when the New Mexico Supreme Court ordered the judge in Doña Ana to hear the victims, he responded in court with contempt and obvious resentment towards the victims and some of our family members when he asked a question that was tried to be answered by my wife. He reprimanded her after asking her a question. This behavior was just 7 years of repetition. Repetition by a man who had no consequence for not following the laws. In the end, an admitted sexual offender was offered more respect and decency by the court than the victims themselves. Then he was released from his consequences earlier than was initially promised to the victims. I can assure you, if your child, your young daughter, was to experience sexual offense, you would not want to have to also re-experience her suffering again and again through the court system and by a system that was built to protect her. Currently, we have laws without penalties or punitive repercussions, and therefore can be ignored and then dismissed with a simple, non-consequential, and ingenuine, "I'm sorry." I heard that twice. I am sorry. Wait, is that all that's going to happen? You're just going to apologize? Amazing. What we experienced was pathetic. A complete disregard for victims. This was not justice. In fact, this was abuse again by a man. Well, it was actually controlled by a man, a judge, who had no consequence to his actions except to say he's sorry, which, by the way, he never did. Furthermore, I can only describe the favoritism that the defendant, Patrick Howard, the admitted offender, was graced with as favoritism that one friend would give another. For all victims of crime, especially minors and victims of sexual assault, it's critical that New Mexicans require accountability for and enforcement of the Victims' Rights Act. Survivors of these deeply traumatic offenses deserve justice. They deserve protection and the assurance that offenders will face clear and strict consequences mandated as a matter of law instead of imposed by an attorney or a judge's creativity. By highlighting victims' rights and their safety through strong legislation that provides for genuine accountability for the offender and the judicial system, we not only provide support for victims' security, peace of mind, and healing, but also take vital steps towards deterrence, preventing further harm to others. This legislation will reaffirm our commitment as a community to prioritizing victim protection and creating a safer environment for all New Mexicans. Thank you. That's yours. Sorry.
So one of the things that this bill attempts to highlight is what Mr. Ronga just described as a lack of consequences associated with the deprivation of constitutionally guaranteed rights. And I will say again, there is no other class of citizens under our Constitution that have specifically enumerated rights. And if those rights are violated, there is simply no remedy, no recourse. And to the points that Mr. Ronga made about the unfortunate way, but all too common way, that proceedings often happen in this state, ultimately there were no consequences for the violation of the Victims' Rights Act for any participant in the criminal justice system. And that has to change. If we're going to have rights that are articulated under our Constitution, then we have to have remedies. We have to have the ability to give someone a voice in the process, to have representatives, to have advocates, but also to make it abundantly clear to court personnel, to prosecutors, to everyone involved in the criminal justice system that these rights exist on equal footing, not only with the criminal defendants, but also every other group of citizens in our state. And with that, I am proud to introduce the sponsor of this legislation, again, someone who has been a champion of public safety initiatives throughout my time, both as district attorney and as attorney general, and somebody that I know has always placed a premium on the rights and interests of the most vulnerable people in our criminal justice system, and that's victims of crime. And so I'm happy to introduce Representative Meredith Dixon.
Thank you, Mr. Attorney General, and to all of you for being here. And thank you to Mr. Ronga for sharing your story. I am Meredith Dixon, State Representative for House District 20 in Southeast Albuquerque. And in the legislature, I'm proud to serve as the Vice Chair for House Appropriations and Finance, where I help to craft our budget, including our investments in public safety. In recent legislative sessions, we have made progress to improve public safety. We've made significant investments to recruit and retain law enforcement. We've strengthened penalties for dangerous crimes, and we have focused on addressing the root causes of crime. But we have much more work to do. Continued progress on public safety is going to require all of us working together: legislators, law enforcement, city and state officials, and our courts. By working together, we can deliver on the promise of safe communities and swift and certain justice. Like so many of you, I love our community, and I want all our neighbors to feel safe in their homes and on their streets. And when someone in our community is harmed by crime, we all want them to get the justice they deserve and to be treated fairly by our systems. The very last thing we want is for victims of crime to be victimized again by the justice system. That's why I'm proud to be sponsoring legislation to amend New Mexico's Victims of Crime Act by expanding the definition of criminal offenses and enhancing protections for victims. This bill will make several critical updates. First, it adds human trafficking and battery of a healthcare worker to the list of offenses covered by the Act. Second, it allows victims whose rights have been violated to bring a private cause of action against a public agency or a public employer. Third, it strengthens victims' representation in legal proceedings by allowing them to appear and to make statements at all court proceedings, and by letting them do so through a representing attorney if they so choose. Finally, it requires that victims be given notice of scheduled proceedings at least 7 days in advance, so they can make arrangements to participate if they want. And this bill gives them legal recourse if that timeline is not met. All told, this legislation will strengthen protections for victims of crime, make it easier for their voices to be heard, and notably, it will provide victims with a legal remedy if their rights are violated. Victims of crime deserve support as they navigate our justice system, and that is what this bill will do. I want to thank all of our partners for helping to craft this meaningful legislation, and I look forward to your support for this bill in the coming legislative session. Thank you.
Thank you, Representative Dixon, for your continued engagement on important public safety issues and the important cause of advocating for and defending victims' rights. And so with that, I would open it up to any questions that you may have on either of the proposed pieces of legislation.
So this is a,
I don't.
You'll hear it through not through the speaker.
so this is obviously a significant piece of crime legislation regarding victims' rights. The legislature has had a history recently of not being able to pass significant crime legislation. So what would be your plea to state lawmakers to get this legislation passed?
Well, listen, my sense is that there is a growing sense of urgency in the public for meaningful reform inside our criminal justice system. And I think a lot of times things break down in the legislative process because these issues can be naturally divided along ideological lines. One of the things that I have noticed in my time, both as DA but now as Attorney General, is there actually is a lot of bipartisan support for placing victims on equal footing with other participants in the criminal justice system. And so my hope is that that sense of public urgency, combined with the fact that there is widespread bipartisan support for giving meaning to these constitutionally guaranteed rights and to these statutory protections, is something that frankly can break through. I mean, I think we can have a lot of disagreements over about where criminal penalties should be set, for example, or what kind of investments to make before or after the criminal justice system. But the protection of child victims, the protection of sexual assault victims, there are very few voices in our community, very few. I think there are some special interest groups that have an outside amount of influence in the legislative process, but I have yet to come across a citizen in this community who says, you know, you really should keep in place a practice that allows for the re-traumatization of child abuse victims. So my hope is that public awareness and that bipartisan commitment will change the dynamic in Santa Fe.
Esteban with the Santa Fe New Mexican. I'm curious about the efforts to, I guess, limit interviews by defense attorneys from of victims ahead of time. Is that part of a discovery process, and how will this bill allow that information to be afforded to defense attorneys ahead of trial?
Yeah, so it's actually a unique feature of criminal procedure, frankly, that is uncommon in this country. First of all, the right to interrogate child victims is nowhere to be found in the state constitution. It's nowhere to be found in the federal constitution, and it's nowhere to be found in any statute that's been authorized by the New Mexico legislature. What it is a court-made rule by a committee under the supervision of the Supreme Court that has allowed for the process of obtaining these statements. And a norm of practice, right? A pattern of practice has emerged with very little input or guidance from the court that has gone from enabling parties to get statements to this unfettered process where you have defense investigators asking child victims about the kinds of clothes that they were wearing or the kinds of provocative things that they said in a text message, or inquiries, which I know Mike Hart has had, about whether or not they've talked to a counselor or a psychiatrist or a mental health professional. that sadly is something that New Mexico is one of the only states in the country, as far as I know, that even permits that. If you attempted to do something that outrageous in federal court, you would probably be held in contempt by a federal judge. And yet in New Mexico state courts, it's common practice. So we are providing legislative guidance on exactly what it would mean to violate these standards of practice. And we are making it very clear that because of the constitutional guarantees that are afforded under the crime victims safeguards in our Constitution, that you cannot undermine a victim's constitutional rights by a court-made rule. It simply isn't permitted under our system. I know it is likely to face a legal challenge after it's passed by the legislature, but I think that's an important conversation for the judiciary to engage in.
So, one more question. So would an interview, if like an interview by a prosecutor were to happen, how would that be provided? I mean, 'cause I would figure that that's probably pretty important information for a defense attorney to have.
So the bill, with respect to pretrial witness interviews, it's a clear prohibition against interviewing a child. And the reason for that is precisely because of the traumatic impact that Representative Jaramillo talked about. We now know a lot more about the neuroscience of trauma and the neuroscience of repeatedly being asked to relive again and again a traumatic event. And a lot of people don't understand this, but they need to understand it. It's not like recalling what someone had for breakfast or what they did last week. Victims of crime, when they are asked to tell the story again, they actually psychologically are reliving that trauma. And we are doing that over and over and over again. So the bill says you cannot do that with children. It gives the right of adults to either refuse or to limit the scope of questions. But it also provides an important feature, which is independent judicial review for adult victims. And what that means is if someone refuses as an adult to participate in a pretrial witness interview, the defense attorney will have the ability to submit interrogatories, which is a list of questions, to the court. The court can then make a determination about whether or not these are relevant questions or the prejudicial questions or intended to harass or intimidate people. So there's still a process to gather important information, but ultimately the ability for someone to confront their accuser, the confrontation clause, comes from the United States Supreme Court, and the confrontation clause is a trial right. It's a right that occurs in front of a jury and in front of a judge. This doesn't have any impact whatsoever on that right. So if either an adult or a child is the victim of a crime and we need to prosecute the case, they're still going to have to take the stand. They're still going to be subject to cross-examination. We don't have any problem with that, and nor should we, because it's enshrined in our Constitution. But what it does is it forces this process out into the open, meaning the questions that you're going to be asking in front of a jury or a judge are probably a lot more relevant and a lot less traumatic, because the last thing you want to do is traumatize and re-victimize that victim in front of a jury, which tends to keep the behavior in check. What we're worried about is when a judge isn't there and a jury isn't there, and we get a whole range of questions which are not really geared towards guilt or innocence. They're geared towards intimidating somebody and harassing somebody and re-traumatizing victims.
Hi, is there an increasing frequency that you're seeing victims go through this within the justice system that has brought this forth now today?
So this has been a problem that prosecutors and attorneys who represent victims of crime have known about for years. And I think it's actually relevant for the legislators who are here and also the members of the body who are routinely receiving reports about the efficiency and the functioning of the criminal justice system. One of the things that you will see in reports from our legislature have to do with the dismissal rates, in particular the dismissal rates that you have for violent crimes and the dismissal rates that you have for sexual assault and child abuse cases. Well, one of the things that is not included in that report when they talk about New Mexico's high dismissal rates is the fact that our system permits pretrial interrogation and reinterrogation of these victims to the point that they no longer want to participate in the process. So what I can tell you is that this process leads to fewer victims being willing to go forward, being willing to testify. I cannot tell you how many times our sexual assault or child abuse prosecutors would come out and say, case is over, case is dismissed, because either the child or the parent was so outraged by the disrespect, by the invasion of privacy, by the infliction of new trauma, that they said, you know what, this isn't about justice. This is about something else. And so this is, sadly, a feature of our system that has been sitting in plain sight for way too long. And my hope is, with the renewed attention on public safety and the operations of the criminal justice system, this is an opportunity to bring balance and really put justice at the center of the system.
Hi. The court system and the legal system, there's that statement, no victim, no crime. You know, they get scared and don't want to testify or
Yep.
proceed with. Can you explain that to people that don't understand that, because there's a lot of frustration, like, oh, the trial didn't go through, and then it's because of that. And also, with all these laws that you're proposing, how will that strengthen the victim with a coalition of people to get it to the courtroom?
Well, I think what this is a piece of a much larger conversation that needs to be had in the legislature, and quite frankly, I've never really seen it had, which is a conversation about the procedure inside the criminal justice system. I get asked all the time, I get asked by legislators if I could provide one piece of advice, one thing to try and fix the system, and my answer is always the same. Adopt the federal rules of criminal procedure. If you adopted the federal rules of criminal procedure, which upholds our constitutional guarantees, it protects victims of crime without creating unnecessary burdens, without impacting law enforcement, detaining dangerous people when they needed to be detained. If you did that one thing, you would have conviction rates go up, dismissal rates go down, in a much safer community. But that's a very complicated conversation. So what we have to do is take discrete pieces of the system that we need to fix and focus everyone's energy on that. And so that's why this is such a critical component, because to your point, if victims believe that they have no protection in the system, if they believe that they go into a pretrial witness interview without an attorney or without a voice in the courtroom, or with a judge that can disrespect or disregard their rights without consequence, that leads to one thing: a victim that's less willing to go through with this process. And guess what? They talk to other victims. They talk to other family members. So if you have been a parent, if you have been a victim, and you have lived this nightmare in our system, and then you meet another victim and they're on the fence, this happens all the time. Should we report this? Should we do something? What's going to happen? And what I have to tell them honestly is, you oftentimes will get raked over the coals. You will be the last person in the system, the last person in this process that the system thinks about. And it doesn't have to be that way. We can create a system that balances victims' rights, that upholds our constitutional guarantees, but doesn't do it at the expense of victims and their willingness to participate in the justice system.
We've got one question on the Zoom from Dan Boyd of the Journal. We're going to ask you to unmute yourself and ask your question.
Hi, good afternoon, can you hear me?
Yes.
Yeah, I just wanted to clarify, it sounded maybe like we were talking about several pieces of legislation. I know Representative Dixon had talked about, creating a new private cause of action in addition to kind of these protections for victims, and just wanted to make sure I was understanding that right, and if you could kind of clarify whether that was all in one bill or several different bills we're talking about here.
No, thanks for your question, Dan. There are actually two separate bills. The first bill is going to be sponsored by Representative Torrez, and that is to provide additional safeguards and frankly, prohibitions against, for example, interrogating child abuse victims in advance of their criminal proceedings. So that is one bill. Representative Jaramillo introduced a version of that bill. We had actually talked about this several years ago at the district attorney's office, and so that is a concept that is well understood. We can provide a summary of the bill and the specific text. The second bill, sponsored by Representative Meredith Dixon, would create both a private right of action, but also give the New Mexico Department of Justice enforcement authority over any violations. So, for example, if a court clerk set a case or set a hearing in a case without giving adequate notice to the victim, we not only will trigger a violation that could be vindicated both through a private right of action or a civil enforcement action by this office, we also set up an expedited appeal process to an appellate court. And if the appellate court finds that there were no exceptional circumstances for shortening the notice period, they could vacate that hearing and force the participants to start all over again. But the fundamental thing that we're trying to do is to create agency, to create a private right of action and an independent enforcement action, so that we have the ability to protect people's civil rights. Because we don't think about it in this way, but you should think about it in this way. Victims' rights are civil rights just like everyone else. And when a police officer abuses someone on the street or violates the Fourth or Fifth Amendment, they have a right to take that officer to court. Well, why would we treat victims any differently? Why are victims somehow less than or not entitled to the same kind of treatment? And the Victims' Rights Act, when it was initially constructed, explicitly said that they weren't creating a private right of action, and we are proposing that change. All right. Thank you again for being here, for covering this story, and for elevating the voices of victims in our criminal justice system. This is a hugely important and consequential step forward, I hope, for our criminal justice system, and I look forward to debating these issues and supporting the sponsors when these bills come up in January. Thank you so much.